Hey guys, today we are here with Thomas Feerick with Feerick Law and Realty. What's up, Thomas?
What's up, Haley? What's up, Ryan?
Hey.
Yeah, good to have you, man.
Thanks for having me.
Thomas has saved our butts in numerous transactions. We've been able to refer him to tons of agents and investors that we work with, and we're super stoked to have him here and kind of share with you guys a little bit about how he can help with the transactions, where he can step in, and where his biggest referrals come from agents.
Yeah, let's start with a little bit about you, a little bit about Feerick Law and Realty, and your history in San Diego, and kind of maybe give us the top 3 categories of what you guys do there.
For sure. So I'm born and raised in San Diego.
Not many of us. 4 in the room. 5.
Wow.
Right.
Born and raised University City by the UTC Mall a little bit. I only left for 4 years of undergrad in Santa Barbara. I came back, went to law school.
Go Gauchos.
Go Gauchos, baby. Went to law school locally at Cal Western. Graduated. I worked for a bigger firm for about 5 or 6 years out of school. And then I felt I was ready to go off on my own, which I did about 3 years ago. So Feerick Law and Realty is a full-service law firm and real estate brokerage. I myself have my broker's license as well. But about 95% of our business is strictly lawyering as well. We do all facets of real estate law, all facets of construction law as well.
Okay.
And so we feel the construction aspect of it brings a unique viewpoint to our real estate clients because obviously agents work with a lot of developers, right? Mm-hmm. People who deal with contractors on a daily basis. So they need advice and help whenever a dispute arises on that transaction as well.
So the construction stuff informs the real estate informs the construction stuff.
100%.
Gotcha.
Well, and you've worked on some pretty big cases, like against the city and stuff too,
yeah.
right? Like Caltrans and those kind of construction.
We do a lot of public works as well. So people who are building bridges and freeways and that pure water pipeline project that's holding up traffic all around San Diego right now. Represent a lot of people on that. And the public works cases are the big ticket items, the $10 million claims, $15 million claims. So we pursue that on behalf of the contractors. Alternatively, we can represent the owners as well if they want to sue the contractor. Those are very technical cases, a lot of statutes involved. That's why I like more of the private work stuff a little bit better. The money's not as big, but it's a lot more personal for the firm because these people obviously have a lot at stake in these jobs, right?
Yeah.
The public agency owners, they don't care. They have a $100 billion budget, right? But if you got a developer out there who's leveraged to the neck on a job, they need our help right away. Gives us a little more, personal involvement in the whole situation.
Well, and that speaks right into how Haley and I know you best is we've referred easily over 50 families / real estate professionals, lenders, realtors, you name it, from everything from eviction to, I mean, I wanted to go through exactly what you're seeing on that side. And actually the first one was really surprising, what you spend most of your time litigating and dealing with in real estate law.
Yeah. We've seen it all, us three, I feel like.
For sure.
Yeah. So going back to your original question, the 3 practice areas for real estate we see the most. Number 1 is non-disclosure, right? So whether you're a buyer's agent or a seller's agent, let's say the transaction closes, the buyer lives in the house. After the closing, an issue arises, leaky plumbing, mold in the HVAC, central heating and air not even working, the roof is leaking, maybe the foundation is damaged as well and the house is slipping into the ground, right?
Oh, man.
Seen it all on that regard. And when that happens, the buyers, they get angry. Why wasn't I told about this, right? The seller should have told me. Seller's agent, the inspector, my agent, my broker should have told me about this, right? They're not necessarily right in that regard, but I will say if I represent a seller, no offense to all you agents out there, or if I represent a buyer, sorry, no offense, but we sue everyone. We were talking earlier about a case I just came from court on where I represented a buyer. We sued her agent, her broker, seller's agent, seller's broker, all 3 contractors that worked on the property. They're bonding companies, her inspector, right? About 14 defendants total in this entire case.
Wow.
So it gets very, very hairy. But for all you agents out there, there's a way you can protect yourself. Don't worry.
Do tell. Do tell.
So I
we
tell,
lead with the scare tactic first,
everybody's attention.
Everyone's okay. So the biggest thing I tell my agent clients, because like I said, we represent everyone in the transaction, right? And so if you're an agent and you get notice from a buyer of a pending lawsuit or a claim or whatever, and you want to come consult someone like me, my first question is, I need to see all your text messages during the transaction. I need to see all your emails during the transaction, right? Some agents are good. Their CRM software records everything that they do. Some agents, not so much. They say, oh, it was all a phone call. That's just the way I do business, right? Which is fine. Don't get me wrong. But at the end of the day, if something does resort to a formal lawsuit, the judge is going to look at the documentary evidence because you have your side of the story. The buyer has their side of the story, right? You have incentives to ensure that your story is true. The judge is going to look at the objective evidence, right? So that's why I advise all my clients in a transaction, record everything via text or email. If you want to call them and talk about an issue with the inspection report or an issue with your agent visual inspection as well, that's fine. You can talk to them on the phone, but do a follow-up email. Hey, this confirms our call where I talked about X, Y, and Z, right?
Yeah.
Or send them a text. This confirms our call, X, Y, and Z, right?
So everything documented or salient points, negotiating points, things like disclosure items, you want to definitely cover?
Salient points. You don't need to be like, okay, call them. I'll meet you at the house at 2:30 on Saturday. This confirms our call. I'll meet you at 2:30 on Saturday, right? I'm not saying you need to get that crazy with everything, but you're right. Salient points, disclosure items when you walk through the property with the buyer, and all of that. And even for the sellers, right? If you're a seller's agent and your client is preparing the disclosures to give to the buyer, a lot of agents obviously tell the seller, write down everything about the house, right?
Yeah.
So when I get that, or when my clients get that from the seller, I tell them, send an email or a text message. I want you to know that we need to disclose every single thing. Is there anything on this piece of paper that you haven't told me about, or that is an issue with the house? That covers the seller's agent, but because they satisfied their obligations under the law to ensure that everything is being disclosed by their client, right? So that all goes back to the original point, document everything that you can, the salient points, the inspections, stuff like that.
Yeah.
Because the court's going to look at that at the end of the day. I've had cases where agents have gotten out of it very quickly. If I can show the judge in a pretrial motion, or even opposing counsel, if they're reasonable. A lot of unreasonable lawyers out there, as I'm sure people know. Yeah, no. But if I show them the record and I say, look, you're not going to win against my guy. He's not liable. He did everything, or she did everything that they could to ensure that the disclosures were properly made, they'll get dismissed and it's all good.
So like an ounce of prevention is worth a pound of cure.
100%.
Okay. So I have a question. What if like they go into contract as an as-is property and, stuff comes up on the inspection report. It still is purchased as is, but then there's stuff that maybe arises that wasn't on the inspection report, but you purchased as is.
Yep.
Now have you seen that happen before?
I got a case like that right now, actually. Yeah. I have a guy, very wealthy individual, sold a property for about $3 million down in National City, and the buyer bought it as is. But during the transaction, he came to me and he said, even though it's as is, what else do I need to do? And although it's a little belt and suspenders, I over prep, I always tell him, disclose everything anyway, right? If the buyer wants to make a stink about it and they want to seller credit or whatever, we'll negotiate that down the road. But a $5,000 seller credit is a lot better than a $3 million lawsuit at the end of the day for something you didn't disclose.
Absolutely,
right?
Yeah.
So we disclosed everything. There was the roof hadn't been repaired in about 5 or 8 years, I want to say, and it wasn't actively leaking by any means. But of course, we closed the transaction, and the buyer sues my guy for a leaky roof, and it's right there in the transfer disclosure statement and the seller property questionnaire. The roof needs to be repaired. The judge threw it out within 2 months. And the buyer had to pay my client's attorney's fees and costs because it was such a frivolous lawsuit.
Wow.
Yeah. So even if it's an as-is property, I still advise you to disclose everything possible. And if you as the seller's agent are a little wary, well, if I disclose this, it could be like $100,000 issue, right? Maybe the whole roof needs to be replaced or what have you. That's when you talk to someone like me, and we can get around it to make sure you're operating within the confines of the law, but also making your client happy, because you're not going to get hit with the seller credit for 100
G. Yeah.
You know what I mean?
Wow. Yeah. So you can definitely save a lot of people in some
100%.
transactions.
Yeah.
And I also know you do work with a lot of investors, right? And helping them with their contracts, helping them making sure that they're all protected, and that whenever they're purchasing properties, to make sure their contracts between their negotiation and the buyers and sellers are solid, right?
Yeah. So that dovetails into the original question, my top 3 practice areas. Number 2 is, creating business entities for investors, joint ventures, LLCs, whatever it is, where they plan to purchase a lot or a property, remodel it, develop it, sell it after the fact, or rent it out to tenants, right? We help them with that. So we'll do an initial consultation, identify their goals, who are the investors, how much money you're putting in, how much you're financing, or is it an all cash deal? All of those things affect what type of business entity they should form going forward.
So like whether it's an S corp, LP, or LLC.
Yep, joint venture, whatever it is, right?
Cool.
And so sometimes investors themselves are the contractors, and they'll save money by doing the construction in-house, right? If that's the case, then we can help them ensure that they form the proper entity, because in a joint venture situation, when you have 2 or more business entities coming together to develop a parcel of property, if one of the guys is an in-house contractor, everyone else needs to get their contractor's license as well, which is no good. Oh, man. So we advise an LLC in that situation. I've seen it happen before where the joint venture comes to me. The contractor state license board is the California state agency that supervises all the licensed contractors. And when you form your joint venture, you have to get a separate license, right? The original partner who's licensed can just simply substitute in for the joint venture, but then CSLB says, is everyone else licensed, right? And then that guy's license gets in trouble. It's a whole quagmire of issues that are best avoided if you talk to someone like me before, you know what I mean?
Unwinding that must be pretty daunting.
It's pretty daunting, for sure. Especially when a lot of money's involved, because you got to unwind all the money.
I have a wild card question. Is a buy-sell agreement ever advisable, or is there just always a better way to go?
It's always a better way to go, liability-wise as well.
I could see that.
A lot of people, they'll form a corporation maybe, and they'll develop multiple properties. That's not really advised. LLCs and joint ventures are the way to go, because once the job is done and the property's sold, you can dissolve the LLC, and if someone wants to sue the owner or the developer after the fact, LLC's dissolved. You're judgment proof, right? Can't get it.
Like so the person to sue is vanished.
Yeah, they vanished essentially. So, there's a lot of different ways and nuances you can go about doing it. And on that transaction, once we get the business entity formed and developed, we can do, the purchase contract as well for them to buy the land, right? Maybe there's a seller financing aspect of it. We'll do the note, do the deed of trust, right? We'll do all of that for you guys. Working with title, obviously, and escrow as well, to make sure everything's above board and legit. And we help the investors, during the construction of the project as well. If they're not doing the construction themselves, they need a general contractor, a contract with them, subcontractors, insurance, right? The whole 9 yards. You want to make sure you're indemnified if the contractor does something to the property, someone slips and falls on the property. You get sued. Indemnity means the contractor pays your attorney's fees and costs and any settlement that eventually goes to the person who's suing.
Gosh, it's just so much you don't think about.
Yeah,
it's a lot.
Well,
a lot of stuff.
It makes a lot of sense when I hear you talking about having the entities and LLCs and joint ventures, because a lot of our investors we work with, when they do flips, it will normally be in the LLC of the street name, 123 Sugar Maple Street LLC, and that's the street we're selling, that property. And then it makes a lot of sense because they're able to dissolve that entity after it sells, create a new one for their next flip that they're doing.
Totally.
Yeah.
A lot of people come to me and they're like, well, that's a lot of work doing an LLC for each one. And I'm like, well, it's a lot of money if you get sued and you're on the hook. So like you said earlier, an ounce of prevention is worth a pound of cure. Did I get that right? I might have mixed it up.
Yeah.
Sorry. And so
it works for so many things.
It does. It works for so many things, especially in the real estate context as well. And then, when the job is done, they have agents who sell the properties for them as well. But the standard CAR forms that they use, the real estate purchase agreement, the amendments, stuff like that, we modify those to ensure that our clients are protected as well. We get pushback sometimes from the buyer's agents. This isn't a standard form, but my clients in that situation have the leverage because they're the ones who want the property. And, the market's, you can correct me if I'm wrong, slowed down a little bit. This isn't COVID anymore where houses are flying off the market. But if you have a really nice home that was remodeled or built from the ground up, it's a lot more attractive than the other properties on there.
For sure.
So we add, Civil Code Section 1542 releases, all known and unknown claims. That way, if something does happen, you signed this release, you can't sue us. stuff like
All
that.
known and
So is
unknown
that like
claims.
so like
Yeah.
mechanics
That's a catch-all.
liens and things like that? They
Yep.
won't arise because they can't be sued for them.
Right. Well, anyone can sue anyone for anything.
Yeah,
obviously.
this is true.
But we can easily get it dismissed if it comes to that by showing the judge, here's everything they
And
signed.
they agreed to it.
Yeah, and a lot of our practice, we're trial attorneys. We do litigation, so we're in court all the time. 30% of my lawyer practice is also transactional, which was what I just talked about, doing the business entities, all the stuff that happens on the front end before it gets to a lawsuit. But the fact that we litigate all the time gives us the insight to ensure and foresee this could be an issue, and we overcome it in the beginning with the modifications.
And you're
to
in
the
mid-season form at all times because you're in
Always.
the courtroom dealing
Always.
with
Yeah.
So we have disclose.
Right.
Get your entity straight.
Yeah.
Right. And talk to Tom.
Yep.
And numero tres.
Evictions.
Okay.
Big
Keep you
problem.
busy?
Yeah, big problem.
Oh no.
Those are, they're not necessarily big ticket items in terms of money, but obviously if you have a squatter in your property, you need to get them out as soon as possible.
Yeah.
And if you lose a sale because of the squatter, obviously that becomes a big ticket item too, right? The problem with evictions is California is a very pro-tenant state. Even if this guy or girl doesn't pay rent for 6 months, you still don't have a clear-cut claim to get them off the property, okay? There's also a lot of technical steps you need to follow in the statutory scheme for unlawful detainer, they call it. That's the legal term for an eviction case. For example, if you serve a 3-day notice to pay rent or quit, say the guy or girl owes you $2,000 in rent, your lease says I can charge you a $200 late fee, right? So you owe me $2,200, $2,000 for the rent, $200 for the late fee. We file our unlawful detainer case. We prove our case. The judge looks at the 3-day notice. The law says you can only have your rent. You can't have any late fees in the notice. Therefore, entire case dismissed, judgment for the tenant, right? A lot of people don't know that. I've had that happen before where landlords come to me, I don't need a lawyer to serve the 3-day notice. I'm okay. And there's defects in it, right? Tenant's name is spelled wrong. The amount of rent is not calculated properly. You left the unit number off the address, right? Little things like that can get the whole case kicked.
So it has to be impeccable.
Impeccable.
Wow.
And the Tenant Protection Act of 2019, which the legislature enacted during COVID, has even more protections where if it's for non-payment of rent, you got to serve 2 3-day notices.
Oh, man.
And that's actually for any breach of the lease that is curable, they call it. Your lease says you can have 1 dog on the property. You have 3 dogs on the property. Here's a 3-day notice to get rid of the 2 dogs, right? If they cure that, they can stay in the property by removing the dogs. If they don't, you got to serve a second 3-day notice to quit. A lot of people skip the second step because they simply don't know, right? I mean, don't quote me, but I think it's Civil Code section 1946.12 is the statute.
That's pretty
Don't
impressive.
quote me. Plus or minus five sections
Somebody's
on that.
in there
But
searching that
The
code.
statute itself it's long. I mean, that one code section is probably 4 pages of dense text, right? So
Wow.
it's crazy. So evictions are a big ticket item, and the problem in San Diego County anyway, there's one judge hearing all eviction cases in the downtown location, right?
What's the backlog like?
So procedurally, you file your unlawful detainer case. Tenant has 10 days to file their response. Once they file their response, I have to file what they call a request for trial, request my trial date. By statute, all these cases need to be heard within 30 to 45 days. It takes the court 3 weeks just to process my request for trial because of the backlog. Then I get a trial date 30 to 45 days after that 3-week waiting period. We go to trial. It's usually a 1-day trial, probably no more than 2 hours because it's a very simple legal case to prove. Did you pay your rent? No. I mean, it's not that simple. Don't get me wrong, but that's the gist of it, right? The judge will issue his verdict right there. Who's right? Who's wrong? If we win, I got to file a separate document, the actual judgment, right? Here's what the court ruled. That's going to take the judge 30 to 45 days just to sign. Okay.
That judge is exhausted.
Yes, 100%. Peter Murray, Department 501. I feel bad for you, sir. I was actually,
Some help.
I was actually in his courtroom this morning for an eviction case as well, on another procedural matter. But I can tell you, you can be there in person or you can be there on Teams. There was probably 100 people in the lobby on Teams just waiting for their case to be called. It's crazy.
Get that guy a Red Bull.
I know. He needs a raise for sure.
Oh, man.
And so that being said, the judgment comes back. Squatter's still there. You can't lock them out. You can't change the locks. You can't cut off the heat. You can't cut off the water. That's a constructive eviction. That's not only a civil penalty for the landlord, it's a criminal penalty too. Misdemeanor. So that you can't do that. So once I get the judgment back, I got to file another document. It's called a writ of execution. It says I got my judgment on this date.
We're like 90 days in now.
Oh, 100%. Easily 3 to 4 months before I even get the document, which is called a writ of execution. That is the document you send to the sheriffs to get the sheriffs out there to forcibly remove them from the property.
And what are the turn times with the sheriff?
San Diego County, now they're better. It's about 2.5 to 4 weeks, I would say.
Right.
So from start, their first 3-day notice to finish, average timeline for an eviction is probably 6 to 7 months. And during the entire time, you can't accept rent because that's a waiver of your defense.
And that's if you have an attorney who's making sure all the notices are
100%.
impeccable and every procedural checkpoint is done right.
Yeah, I mean, people could go a year without paying rent. And then on the flip side of it, even if you, as the landlord, put a judgment on the tenant for payment, and that, like, obviously these people don't have money to pay. So then how long are you waiting to get your payment from these people too? Like, that's a whole nother thing.
So collections is what they call it.
Yeah.
The post-judgment collection proceeding. These tenants don't really have any assets, right? It's very rare that you have a tenant with a lot of assets, equity that you can collect against, right? 95% of the time, you know, they barely have anything in their bank account. And so my clients think they're protected because, oh, my lease says I get my attorney's fees and costs paid for if I win. The judge will award the fees, but it's like a piece of paper, right? And so I take that piece of paper. I need to file liens with the county, but what am I going to lien? He doesn't have a home, doesn't have equity, doesn't have a savings account, doesn't have any crypto, right?
Yeah.
Doesn't have anything.
What are you going to collect on?
Exactly. So
maybe his car's paid off.
Maybe. I can garnish his wages, right? But how much is my client really going to get out of that whole thing? So, you know, I say to all my clients, there's the legal process, there's the practical real life process. A lot of times you might have the best legal claim in the world, right? This applies to real estate law, construction law, evictions, whatever. But it makes better practical sense, or business decision, I like to call it, to buy them off and get them out early. So a lot of my landlord clients, I'm like, you're going to pay me anywhere from $3,000 to $5,000 maybe to do the eviction proceeding. Offer that to the tenant to get them out, right? Just say, hey, I'll give you $3,000. You don't have to pay me rent for the next month. Just get off the property. And a lot of times that gets what the ultimate goal is, right? Is to get them off the property.
Yeah.
Landlords are like, you know, F that. Why would I do that? They're the ones who owe me the money. And I'm like, put your emotions aside. This is better for you. It's not in my best interest to say this. I would gladly take your money, right?
Yeah, but let's make a business decision
but
here.
you need to decide what's more important to you. Proving a point or getting them out.
Cash for keys?
Cash for keys, essentially. And of course, we would draft a legal document. It's called a stipulated judgment. So that judgment I talked about earlier, that takes 4 to 5 months to get. You can get it immediately upon them signing, right? And of course, you don't pay them anything until they get off the property. I like to do like a half now, half later situation just to show like good faith. But the stipulated judgment is literally everything you need to get the sheriffs out there. So if they breach, you can get the sheriffs out there immediately, right? So some tenants are very, you know, woe is me. I don't have anywhere else to go. I'm going to stay here no matter what. I actually had one. This is a funny story. This rich lawyer from LA, personal injury guy, bought a house at auction in Oceanside, $2.2 million cash he paid for this house. Whoa. Yeah. And the house was being foreclosed on by the lender because the owner hadn't paid his mortgage in like a year and a half, right? My guy buys the house. The squatter refuses to leave. He's like, I'm not leaving. I'm not doing anything. I have to file an unlawful detainer action in that regard and go through the whole process. So for, I think it was 7.5 months, this guy has been living in the house, hasn't paid his mortgage for a year and a half, hasn't paid any rent, been living there rent-free. Meanwhile, my guy
Your owner, is
already out of pocket the $2.2 million that he paid for the house, could have made interest on that during this entire time, whatever, right? And so on the day before the sheriffs were going to get out there, he leaves and just says, okay, I'll see you guys later. So, you know, that's crazy, right? And my guy, being a personal injury lawyer, he's like, I don't know how, like, keep your composure. This is such bull. And I'm like, I know, but I swear to God, he wanted to cut the heat off. He wanted to turn the water off. He wanted to, like, literally just walk in there and start living there. And I'm like, all of that is against the law.
Even though he owned the property.
Even though he owns the property free and clear.
Wow.
Because it would have put him all the way back to step one.
All the way back to
That's
step one.
So now, what about these guys that go in and they like play loud music and they go in and they bang tambourines together in the middle of the night,
like outside the house? What are they called?
I forget what they're called.
The legal term for that is a nuisance.
Okay.
So they're creating a nuisance on the property, right? A
Is
lot
that
of those.
constructive eviction, or could it be interpreted as such?
Oh, sorry, I misunderstood your question. You
Yeah,
meant
like
the landlord goes and plays
like there's
music
these
outside.
companies.
There's third-party companies.
Third-party
you can
companies,
hire.
yeah. My opinion on them is it's a gray area, 50-50.
Okay.
If you hire someone like that, that's well within your rights. I don't, if a client comes to me and says, I want to have these people, do those things, I advise them of the risks. Some judges might say it's constructive eviction. Some might say it's pressuring them to leave, which is also against the law. Other judges who are more pro-landlord might be like, good, play it louder. Let's go.
You might piss off some neighbors.
An act of God, right?
Yeah.
You don't know how they showed up there.
Yeah.
It's weird.
So California, the county, I should say, there's a courthouse in El Centro for evictions, courthouse in downtown, courthouse up in Vista. They call it North County, right?
Uh-huh.
So 80% of the eviction cases run through the downtown courthouse where it has the one guy, Peter Murray, Department 501.
Sorry, Peter.
Poor Peter. But this has got multiple judges, and East County's got multiple judges. Not East County, El Centro, sorry. And so, that's why it's more of a gray area when I have clients up there. I do know if you have a property where it's going to downtown, I would advise you not to do that because I've seen them rip people, for doing that before.
Okay.
So, it's just tough out there for landlords. I don't get why, I guess I do. The legislature enacted these laws and it's, the will of the people, whatever. But these landlords, some of them aren't like multinational corporations, right? They're just families, mom and pop, who pay the mortgage every month with the rent money that they're getting.
Yeah.
And I've had clients not pay the mortgage for 7 or 8 months because their tenant's not paying the rent. Now their house is getting foreclosed on, and it's just a whole.
It can sink a mom and pop investor. It can
100%.
sink a family who's just trying to rent out, a duplex that they inherited or something.
It's crazy. And so, that's why all of my landlord clients that come to me, let me look at your lease. Who drafted your lease, right? The standard car form residential lease is pretty strong for landlords. It could be stronger. Okay. I have edits that I make to that lease as well via an addendum just to make it even better for the landlords. One of the big things is that Tenant Protection Act I talked about. The statute says you can be exempt from those requirements for certain reasons, right, which are legal terms. But the big thing is you have to disclose that exemption in your lease. And if you don't disclose it, even though you might be exempt for X, Y, and Z, you cannot claim the exemption because it's not disclosed to them.
There's the D word again.
Yeah, there it is.
Always disclose.
Always disclose.
Oh,
and so, it's crazy. So anyway, the standard car form has that exemption in there. It's basically just a box you check. But a lot of landlords, I don't need a lawyer to help me out. I don't need to spend any money. And so they draft their own lease, and it's all messed up, and it's hard. So clients out there, landlords, we help them draft the leases to make sure they're protected to the maximum extent possible before something like this happens.
Yeah.
Man,
it's crazy.
What a benefit you are to the real estate community. Seriously, you don't want to walk into a courtroom without representation. You want to have somebody fighting on your behalf, and if possible and highly advisable, get them to advise on what you're doing before there's any skirmish, before there's any issue, and that has to do with disclosures with entities, and if you can make addendums to the lease to protect them even further on the landlord side, then you're just avoiding with prevention.
Yeah. Like I said in starting this video, Thomas has helped us out on countless, from HOA liens to eviction processes on countless transactions. And every time I refer him, I tell the people he has saved our butts hundreds of times, it feels like at this point.
We have sent scores, if not more, of referrals over, and all happy 5-star reviews, and it's just you're a wonderful asset to us. But I think I'm so happy so many are going to get to know you in this process because you need to go to war for these guys and back them up.
100%. Yeah, and I appreciate you guys too. I mean, obviously, we go back and forth. I love you guys. We've seen it all.
Yeah.
The HOA disputes are my favorite because no one likes their HOA. And I'll just say one more thing. You agents out there, and Ryan and Haley can attest to this. I'm not one of those lawyers, or our firm doesn't charge you a straight up fee just to talk. If you guys want to chat, just give us a call. I'd be happy to advise you on any situation you have. A lot of benefit we can provide is that, you can help advise your client better, look better to your client, right? By coming to someone like us and tell them, I'm consulting with the lawyer, I will get you a legal opinion. It's okay. And so we can offer value in that regard too for you guys out there. So
that's huge.
For sure.
That's, I mean.
So it's not $100 just to talk to you?
No, definitely not. Maybe for you.
No, I mean, he has been such a great resource for us. So agents, if you need a great real estate attorney, look no further. We can refer you over to Thomas. Email him. He's really easy to get a hold of. He's awesome. So thank you so much. We love working with Thomas.
Thank you guys. I appreciate it. Thank you for having me.
Awesome.
All right. Until next time.
Until next time.
Give Tom a call.
I'm Haley.
Ryan.
Bye.
Bye.